number 24, Secky v. New Paltz School District.
Good afternoon. May it please the court, my name is Steve Kimmel, and I represent the petitioner Paltz in this matter. As outlined in our brief, we have two positions. The first is that the motion should have been denied because the defendants failed to make their prima facie case based on an expert's affidavit, which was of no probative value. The second position is that, assuming that the expert's affidavit was acceptable, the plaintiff's affidavit raised a tribal issue of fact with respect to primary assumption of the risk. A close look at the affidavit of the defendant's expert, Mr. Fruscio, reveals that there is not one citation anywhere in there to any authoritative text, standards, regulations, or anything else, although he says repeatedly that the conduct of the drill and Mr. Kenny's coaching complied with all applicable standards. Additionally, he has absolutely no discussion of the dimensions of the court or the safety zones, and he did not visit the gymnasium.
How does the configuration here with the open and obvious nature of the bleachers being there impact the need for those expert affidavits?
Because our position is that the design of the drill, which eliminated the boundary lines, unreasonably increased the risk of injury.
But even if the boundary lines were there, isn't anyone who plays basketball aware of the risk of running into the bleachers, running into the wall, running into another player?
Yes, but this particular plaintiff had played in this gym a number of times before when the boundary lines were in effect, and he had a 22-foot alley on one side and 17 on the other. He had never, in his entire experience, and he'd been playing basketball since he was 7, participated in a drill in which the boundary lines were eliminated. If you looked at the court looked exactly the same.
But aren't there instances, even when boundary lines are there during a game, players fall over into the bleachers when they're extended? Here they were retracted.
Right, but in those instances, the bleachers are always there. In this case, the bleachers were retracted, and it was normally a boundary line with this buffer zone, which wasn't there that day. The court looked exactly the same, and our position is that he couldn't appreciate the difference in the physics involved. Because there were no boundary lines and you could chase the ball at full speed all the way to the wall.
So what you're saying, if the bleachers are open, that's expected, but if they're retracted, you have to have the buffer, even though their retraction means they're not as close.
Right. No, the argument is that he'd been playing with boundary lines his entire career. Like, I'm sorry, the other judge said in the last case, they changed the rules.
So anytime you change the rules, that's a different risk, and assumption of risk doesn't apply?
Not necessarily. It still has to enhance the risk of injury, but in this case it did.
Well, I think you're saying that what happened here was not a risk that's inherent in the game, but we've heard,
Right.
we've heard previously that players go out of bounds all the time in regulation play, and they often run into things and trip and fall, and sometimes they even fall on top of other people. Can you
Yes.
tell me why in this case it wasn't a risk inherent in the game? Maybe you did and I just didn't
No,
understand.
maybe I haven't said it clearly yet. If the two players had collided within the boundary lines, that's an inherent risk in the sport.
Yes.
And
But
that
don't
was-
players often, in regulation play, don't they often go past the boundary lines?
Yes.
They're running after each other or something like that?
Yes,
Okay, so what differentiates that from the scenario at issue here?
because in a normal game, once you pass the boundary line, the ball's dead, and when they fall into a courtside seat or the scorer's table, they're trying to decelerate, they're trying to slow down. In this case, they were still running headlong, full speed, all the way to the wall.
The ball is not always dead after you pass the boundary line, right?
I'm sorry?
The ball could be out of the boundary line in basketball, but have
Yes.
not touched the ground. You could jump from within the boundary line to outside the boundary line, so you and the ball are both still in play. You see that all the time on TV, right?
Yes. And that's one reason why the momentum carries them into the...
Does the record show how far, when the bleachers are open, how far there is between the outline and the edge of the bleachers, or no?
I believe it's in the report, in the measurements, although I don't recall what that was off the top of my head.
That's fine.
He does give the measurement for the bleachers opened.
But it wouldn't be the 17 or 23 feet as when they're
No.
retracted. It would be
No.
much less than that.
No, and in fact, as we pointed out, the nationally promulgated court specifications, which our expert relied on, requires a buffer of at least 3 feet, preferably 10.
So would your rule be that any practice drill that increases the risks over the risk inherent in a game situation, that you're not entitled to an assumption of risk defense?
Basically, yes. I mean, he's accepting the risks inherent in playing the game of basketball, and he's used to playing the basketball by the rules.
So
Here the
any
rules are
practice that
suspended.
varies those rules and increases risk. So if they were shooting multiple balls to the hoop, one of those bounces off the rim, hits somebody in the head, that's no assumption of risk.
No, because I believe that occurs very often during practice, where you see multiple people shooting balls
But
at the
that
same time.
increases the risk under your rule. Multiple balls being shot from different locations in the court.
But it's something that's done routinely in a practice, and it's not necessarily changing the
So
rules
it's
of the
something
game.
not done routinely in a practice that increases the risk. That's the rule.
Our claim is that eliminating the boundaries here changed the rules of the game and increased the risk.
And including rules of practice? Because otherwise I don't see how you're really responding to Judge Garcia's question. I mean, this is just so far outside what is even acceptable in a practice. Is that your point?
Yes.
Or that there's a fact question around that? I don't know, maybe that's what you're...
In a practice during the game with the regulations, the boundary lines remain in effect. As I said, my client had been playing basketball since he was 7. He had never participated in or even observed a drill in which the boundary lines were eliminated.
So there would be other changes, is what you mean? There might be other rules that are not adhered to, let me put it that way, in a drill, but not the one regarding the boundaries. Is that what you mean? Could have a drill with multiple balls, like has been already
Yes.
mentioned.
And that, you would get an assumption of risk defense. If
Because
there's
that's-
multiple balls being shot at the hoop from different areas of the court, somebody gets injured by one of those balls being thrown, they're not looking at that one, that you get assumption of risk for.
My understanding is, and I'm not a basketball expert, is that's a routine practice that's done by every team almost every day.
So regardless of how risky it may be, because the people in the sport, at least at the school level, have accepted that this is an appropriate type of drill.
And the
practice.
players appreciate it. In this case, our argument is that our plaintiff did not appreciate the risk because he was only 14 years old and he couldn't understand the
So
physics.
if you had a player who had done this same practice on, let's make it easy, 4 prior occasions, not hurt in the prior 4, but hurt this time, what, does the assumption of risk apply to that one?
I would argue that it still doesn't. They might argue that it shows he's had more experience and that he was aware of it and could appreciate the risk.
Yeah, so how doesn't he appreciate the risk if he's done it 4 times, or the player has done it 4 times in the past?
Our player didn't.
No, I understand.
Right.
That was the hypothetical. That's the point
I'm
of the
sorry.
hypothetical.
No, what I'm saying is they would argue that, yes, that means that he appreciates it because he experienced it. If our player had observed somebody else doing the same thing and a ball going loose and somebody chasing it and running next to the wall at top speed, he could then appreciate that you're allowed to run all the way to the wall at top speed.
But isn't it common sense? I mean, isn't that obvious?
To a
That people are
14-year-old, I'm not so
running,
sure.
Someone's going to run into me. I might hit my shoulder against those bleachers. Isn't that obvious?
Yes, but if not for eliminating the rules, they wouldn't have been by the bleachers.
So according to you, the player who bumped into him, let's say he was 18, let's say it's a varsity sport.
Okay? They were 14 at the time, actually.
Okay, but in my hypothetical,
ahead.
the person's 18, so we can sue that person now? Don't you think there's some consideration for us to give to what we're doing? Like co-participants now would be subject to liability based on the elimination of the assumption of risk. So the person who threw the ball at the kid that got hit in the eye, the person who ran into your client and knocked them out of the boundaries or into the bleachers, they'd be liable, right?
No, because we're arguing that it was negligent coaching and design of the drill.
Well, let me ask a variation on that question. You didn't sue your client didn't sue the person who slammed him into the
No.
bleachers. Could you have?
If it was intentional, perhaps, but we're not claiming it was. We're claiming it was accidental.
Well, what if it was negligent?
He was playing the game. He was doing the drill as he was told to do it. I don't see the negligence there.
Okay.
If you're told you can run to chase the ball all the way to the wall, and that's what you're doing, and the other guy turns and you hit him, you're doing what you were told to do. Our position is that they shouldn't have been in that position that close to the wall running at full speed, and if the boundary lines were in effect, they wouldn't have been. One of the other statements that Mr. Fruscio makes at page 5...
What if they had put padding on the bleachers? What
That
if
would
they had
certainly-
attempted to ameliorate any possible?
That would certainly help,
excessive
but there have been...
risk, right?
That would certainly help, but I believe there are a number of cases that say that there's no duty to put padding on walls.
No, I understand that, but let's say they did.
Okay?
What would that do to your case?
It might mean the injury was less severe, but it wouldn't change the basic argument.
Okay.
Thank you, counsel.
Good afternoon. May it please the court. My name is Chris Mills on behalf of the defendants, New Paltz Central School District and Coach Keith Kenny. The question I think the court has to answer to here is, did the school make this drill as safe as it appeared to be? That's it. The assumption of the risk doctrine is a measure of duty. A lot of the questions and certainly a lot of the responses talk about causation. And really what we're talking about with assumption of risk is duty. And it's a
So
different
I
duty.
guess I'm having, and it may be that I'm just not fully appreciating the argument. I don't understand what you mean by make it as safe as it appears to be.
So all of
Strikes
the...
me telling kids to run around where there's a bleacher and they might run into it doesn't sound very safe.
The question, since this doctrine was initially implemented, and by the way, that goes long before the comparative fault statute, and I think those cases are still relevant today. But what it says is that if a participant in an athletic activity, and that certainly should include practices, because it includes athletic activities, not just formal sports, but if they are aware of the risk, or more importantly, that those risks are inherent in the sport. And, I think that's, Morgan versus State of New York, which is probably the last time this court addressed a number of these issues altogether. Knowledge of the risk plays a role, but inherency of the risk is that sine qua non. It's the thing that the court ought to focus on. And if the risk of injury, the mechanism of
So
injury...
here, the argument is, if the practice had taken place with the boundaries in existence, then the risk is not increased.
I would respectfully submit that the risk wasn't increased at all over the play in any number of contexts in basketball. One of the things that's sort of missing here is that this incident occurs sort of towards the baseline of the cross courts. I mean, most practices in gymnasiums, even in high school, but certainly if we're talking about CYO gyms, church gyms, AAU gyms, the boundary lines are in very close proximity to the bleachers or the wall. And this court has specifically said the proximity of a fixed object to the playing surface is of no moment, because the proximity is open and obvious. So unless that risk is concealed in some way, in other words, there's a defect in some sort of protective device, then the participant assumes that risk, as long as it's a risk inherent in the sport. And
So here, are you saying, understanding they're running at great speed, and basketball has in fact become quite physical, so they're running and stopping before you crash into it, it is a concern, but it's there, it's open, it's obvious, that it is of no moment that the boundary lines were loosened or not enforced.
Correct, because it's a risk inherent in sport, and there's a great line from a case from 1968. I just was looking at this morning as I was preparing for it. It's a Court of Appeals case. 1968, Stevens versus Central School District. It says, basketball is a sport which requires those who participate in it to race at maximum speed toward the basket, and it is a rare game indeed when players so doing are not carried by their momentum beyond the limits of the court. And that sort of goes back to what Judge Wilson said. People are diving out of bounds. They are running at full speed, especially the older they get. And they are at risk of crashing into fixed objects. In all of the fixed object cases, certainly from the Court of Appeals, but even the cases below in the appellate divisions, in every single one of those fixed object cases, as long as the risk was open and obvious, and as long as it was inherent in the sport, crashing into something, every single one of those cases has indicated that the doctrine applies.
Would it be correct to say that in this situation, it makes no appreciable difference to the rule that you just articulated, that this was a practice and not a game?
No difference. And this court has already addressed cases involving practices and has found that the doctrine applies in those cases.
The place where I get stuck is, you said that it needs to be, the risk is, it needs to be as safe as the obvious risk inherent in the game. And when you change the rules, I don't see that the risks are as obvious anymore. When you do away with the boundaries or you add multiple balls into the game, something has changed in the risk calculus, hasn't it?
I don't think so, and here's why. Because the sport of basketball necessarily inherently involves the risk of crashing into a wall.
So let me then ask you this. Suppose I'm the coach and I tell the players, we got a new drill today. I'm going to throw the basketball against the wall, and I want two players to compete for the ball, and in doing that, I want you to dive and throw your bodies against the wall and try to bring the ball back into play. That's our drill for today, because in the game of basketball, you're going to have to do that sometimes if you want to wind up on SportsCenter. That doesn't, it fits your test, but I would have a real concern about a coach telling a 14-year-old kid to throw his body against the wall.
I understand that, and that's certainly why hypotheticals are always the most difficult thing to deal with when you're standing where I am. That's
Yeah, so
obviously
we need
not
a
a
limiting- we
situation
need a limiting principle
I've
to
thought
the-
about, because it is so far outside the bounds of what anybody would do in a practice. It doesn't serve a purpose towards the overall goal. The drill that's being done here was being done to teach skills that are inherent in the sport. I don't know what diving intentionally into a wall does, but I can tell you that there's drills where coaches roll the balls out, tells two kids from the baseline to run and dive at each other, and kids come up bloody and hurt all the time, because that's a skill that basketball teaches, that hustle, that drive to dive on the floor to get a basketball. So yes, does that...
Is increasing the risk for the purpose of increasing skill a protected activity in this
Yes.
formulation?
Yes.
And are there any limits on that? Can we go to, I know it's a hard hypothetical, but
I
you have to
suppose,
test
Judge,
the boundaries of it.
And I think that's where that unreasonably increased risk exception, which unfortunately I think has actually started to swallow the rule in the courts below, that unreasonably increased risk is starting to turn into a judge's decision as to whether or not that's a question of fact. I think that starts to subsume the rule itself. But I think that's a rare situation, and I think it's, sort of one of those ones that we'd all know if we saw it. In other words,
Well, we've got two right here today, right? We have baseballs flying around, and we have no boundary lines on the court. And I think the counter argument to your statement is that, it was enough of a struggle when we were talking about regular play where all the rules applied, but now we're talking about scenarios where people are being told the rules don't apply, but participate anyway, and you assume the risk of playing in a scenario where the rules don't apply. But I guess you're telling me that that's just part and parcel of what primary assumption of risk Yes.
I think that's likely the reason this court took this case, right, is to consider those issues and to further define, hopefully, for lawyers, litigants, and participants to decide. Yes, I think that when you're talking about unreasonably increase the risk, it has to be something reckless and so far outside the bounds of what is considered to be sport. And that's part of the reason we submitted an expert affidavit. I don't think experts are really necessary in this case, but I think it's important for the court to know that this drill is directly in the middle of what's expected for athletes as young as fourth grade. This is the type of drill that's run all over the state of New York and likely well beyond. This drill is not some, brand new concoction of a coach who's trying to find something new and different. This drill is normal.
What does the drill lose by enforcing the boundary lines?
It stops the boxing out. It stops the toughness. It stops the
Well,
fighting
you still
through
have the whole
adversity.
width- You still have the whole width of the court to do that.
So for example, Judge, oftentimes when kids, dribble out of bounds, they stop playing, but the referee doesn't always call that. The reason that they're, only hard fouls are being called here because the referees don't always call fouls. They can't always see them. So the purpose of continuing play is to continue to fight through the adversity and the physicalness of the activity. And I think that's universally something that is, revered in sport and something we ought to protect. And I think it really gets back to the public policy here, and that was mentioned in the prior case but hasn't mentioned here. I think a ruling from this court on this Secky case that overturns the third department would be devastating, and it would mostly be devastating for youth sports. It would be devastating for those coaches. The coach here is individually sued.
What if the ruling, before we get to doom and gloom, what if the ruling is just, you didn't meet your burden? You might still succeed, but you didn't meet your burden. How is that going to destroy all youth sports in the state of New York?
Because I think it's going to act as a huge disincentive for any coach to get involved at the youth level where they're not being paid millions of dollars, they're not college coaches. Why in the world would you be a coach in a rec basketball league or a CYO team or an AAU team where you're getting paid nothing if you're going to get sued because one of your players runs into a wall, which is a known...
Maybe you just won't do the practice without the rules.
Well, then there's no practice
Isn't that the
allowed at all.
incentive?
I
So
don't...
no coaches do the practice adhering to the lines?
If you're asking me from my personal experience,
No, I'm asking you because you made an argument to the courts.
I have coached basketball for a long time. I have watched countless high school, CYO, AAU youth games. And that's, again, part of the reason we submitted an affidavit from an expert. Those courts are so much smaller than this. The coaches do drills that are far more likely to lead to injury than this. If we circumscribe this rule and it puts coaches, especially those volunteer coaches, at the risk of being sued, we have completely changed sport. And we have eliminated, and particularly for those in...
Is that because the cost of insurance would be crushing?
The cost of
You could
insurance...
insure, of course.
It would especially affect, Judge, those who can't afford insurance. This
Isn't that a decision for the legislature, not this court?
And I think it would be a decision for the legislature to change the rule. And that's my point on the 14A is, and I think it was mentioned by Respondents' Counsel before, if the legislator wanted to change this rule after 14A was enacted, they've had 30-something years to do that, more than that, and they haven't. And so for this court to change would require a massive change in precedent. The rule of stare decisis would be significantly undermined, I think, here. The last thing I'll say, and I appreciate your time, if you just apply the rules as they have always been, I think this case falls just squarely right in the middle of the assumption of risk doctrine.
Thank you, counsel.
Thank you.